this is Paul. Yes. I put some screen prints in my drive, and there was a comment from the California Supreme Court, yes, about prosecutors has the responsibility of a minister of justice and not simply that of an advocate. This responsibility carries with it the specific obligations to see that the defendant is accorded procedural justice, that guilt is decided upon the basis of sufficient evidence, and that special precautions are taken to prevent and to rectify the conviction of innocent persons. Ouch. This rule is intended to achieve those results. All lawyers in government service remain bound by Rules 3.1 and 3.4. Oh. Now, paragraph C does not forbid the lawful questioning of an uncharged suspect who has knowingly waived the right to counsel and the right to remain silent. Pooh. Paragraph C also does not forbid prosecutors from seeking from the unrepresented accused a reasonable waiver of time for initial appearance or preliminary hearing as a means of facilitating the accused's voluntary cooperation in ongoing law enforcement investigation. Pooch. Now, it seemed to me that the prosecutor in Jefferson County, Mr. Hawes, yes, didn't want to hear what I had to say. You decided I was going to have a 1077 as soon as you had me video arraigned for failure to appear. Pooh. Now, this notice, I'm going to talk about that. Notice and opportunity to be heard. Ooch. You know, just looking over the victims' rights of the Department of Justice. Ouch. Seems that victims have to have the court protect their right to be heard and an opportunity to be heard. Ooh. Now, I asked Judge Landis, I said, well, where'd you send the notice of the court hearing? Oh, it was sent to Mike Van Proyen for the last 5 years. Sufficient notice and an opportunity to be heard. Now, I happen to be sitting right here on June 16th of 2017, but during that first court hearing on November 1st of 2017, my public defender said I was having a 1077. Ooch. Without any procedural evidence, without the Port Angeles Police Department calling Jefferson County. Now, I'm suing some prosecuting attorneys today. See, you have to, as government employees, protect procedural evidence. And when you did not have the police actually ask me where I was at on June 16th, and I couldn't show them that I was at the senior center, yes, I couldn't show them that I wasn't in Brennan, Washington, and I've never emailed anybody in the Brennan School District. Oh, I'm thinking that Mr. Cowgill, Ms. Cochran, ooch, Mr. Nichols, pooch. You know, when you refuse to admit the actual evidence that I wasn't in Sequim, Washington, well, you're fucked up prosecution right now. Why don't you give me all the prosecuting attorneys again? Pooch. This idea that the accused is always guilty kind of violates the innocent until proven guilty. Yes. And using restoration laws to make somebody look crazy. Why don't you give me the restoration laws again and the prosecutors that demanded the use of restoration laws? Mental health evaluations, pooch. You know, victims, they're owed what is known as no delay of justice. And I'm sure the petitioner says that I was in Brennan, Washington on or about June 16th of 2017. And as the alleged victim of me violating protection order, you violated her victim's rights even though she didn't sign the protection. Now, you're not only violating my rights, pooch, but every time that you put me in jail without any evidentiary procedures, you violated my rights to not be arrested for crimes I didn't commit because I wasn't in those cities. Yes. And you violated the victim's rights to obligating me to have all those mental health evaluations.